A very good afternoon, everyone. A warm welcome to today's panel discussion on a highly relevant and pressing topic, intellectual property in India, protecting innovation. Firstly, I would sincerely thanks to all our distinguished panelists for joining us today and to our audience for your presence and participation. So, the first question which I would like to ask to Dr. Akshay is how important is collaboration between in-house counsels, scientists, and business units in shaping a successful IP culture?
Thank you very much for this panel discussion, and I would like to take up this question in a way that when we talk about the collaboration, especially for the intellectual property development and its relationship with the business of the company, its relationship with the R&D, and its relationship with the management. See, the important thing is the internal collaboration is very important between all the teams, because nowadays most of the businesses, they are IP-driven businesses. When we say IP-driven means there are certain patents which are expiring on certain dates, and you plan your business after expiry to launch your generic products, or maybe products only after expiry of those patents. So when there is a drive because of the intellectual property, the important factor is what is the internal collaboration within the organization and what is the strategy which is made to strategically launch on the day one expiry of the patent actually. So this collaboration is observed sometimes missing in most of the organizations, and I would say that a person who has knowledge or acumen of business, a person who has a background of technology, a person who has knowledge of intellectual property, and the person who has a knowledge of legality, means the laws, the patent laws, the IP Act, or the Patent Act of different jurisdictions. It's very, very important a person of that kind to trace out who can collaborate all these functions basically. And with my experience, I've also realized that regulatory is another very important factor which intellectual property person should also collaborate, because once your regulatory approvals are there and your intellectual property constraints are complied and your development as a product which is to be launched after a certain date is also developed and within the set timelines. So this collaboration is a very typical collaboration and needs lot of efforts within the organization, and you should have a driver in the company who can drive this collaboration in such a way that all the timelines which you have set for the launch of the product at the expiry of the patent, you are able to meet out those timelines. And you might have seen India is well known for most of the generic drugs basically which are being launched in US, Europe and most of geographies, including in India also nowadays. After expiry of the patents, it's realized that most of the companies are ready and they launch the product after day one expiry of the patent actually. So why I'm saying this question is quite relevant basically to understand that what is the collaboration and what all streams to be collaborated and how this is possible to collaborate. See, a person who is there in the R&D is a technology person, and I heard in the previous discussion somebody has said that project engineers or scientists, they are not able to be managed by anyone, and this is fact also. Because the very fact is their mindset, their thought process is to go ahead to do work, keep working on, keep finding out the solutions, keep finding out a non-infringing process or a product or equipment, machinery to be developed in a way that in a set timeline. So they don't care, they don't listen also sometimes. And to manage a scientist or an innovative person and setting them with certain boundaries and then there is the analytical team, which is also having a lot of pressure to analyze, to reach on outputs that it meets the requirement of the product to be launched actually. So there also collaboration is required, and regulatory person is also a technology background person, so he or she also needs to be complied or collaborated in a way that this regulatory dossier should be made in such a way that it should be accepted by the particular country wherever it is to be launched. And then business team is also behind all the time that the product development should happen, its trial in the pilot scale should happen in time, and then its commercial manufacturing should also be seamlessly done, and then commercial product availability should also come in time basically. So the person who can drive, in my experience I realized, is a person who should be a in-house IPR person, having a background of at least science and technology, along with the knowledge of legal, means he or she might have done the at least law graduation or post-graduation, and should have proper understanding of IPR, and is a person who masters in writing or drafting the patents and claims and can interpret the claims legally. And once these things are there in the in-house IP person, the collaboration can be achieved, and the person can also guide with the timelines that, these patents are expiring on so and so. He or she can make a patent landscape, what are the risks and other factors. So I have seen with my experience, a person with the IPR with technology background is the must who can do the best collaboration, and it's a need of time for most of the organizations who have to come up with the products which are driven by the timelines.
Shweta, would you like to add something?
I guess over here I would like to add a point. IP management softwares, like technology plays a role over here. Like it helps you keep track of all the IPR that a company manages, right? Because human mind is, you could say that bound to error, but technology built on IPR management can help remove those errors in the company.
So next I would like to go ahead with Shubham. In the highly competitive and often research-intensive fluorochemicals industry, how does your company balance the need for public disclosure required by patenting with the desire to maintain certain innovations as trade secrets?
Thank you, Manishi, for the question. And as per the chemical industry perspective, the invention disclosure forms helps the IP person to identify the invention shared by the scientist. So whatever the scientist has done in his lab, they share all the complete details with the IP in-house person. They evaluate the inventions, and based on that, how the invention is, they conduct a detailed search of the analysis, like different searches. He does a FTO searches, he does a patentability searches, and he does invalidity searches, and everything in case any of the prior art comes up in the picture. So looking to those things, the invention things and the trade secrets. So the in-house IP person plays a huge role in this particular things, that he identifies the complete invention, and he thinks that he as per the jurisdictions wherever it is applicable, and what are the business perspective, because all the inventions needs to be protected as per the business goals of the organization. So this plays a huge role by the IP in-house person, and he conducts every detailed analysis and searches, and based on that he comes up into the things with a conclusion that whether it can be patented or whether it can be protected as a trade secret of the organization. So yeah, that's the perspective.
So how long can this trade secret be protected?
So trade secrets do not have any particular timeline. There is no validity of it until and unless the trade secret can be protected as a secretly by the organization. That can be a case that can be valid to a lifetime. So let's take an example of a Coca-Cola recipe. It's still a trade secret. Maggi masala, it's a trade secret. So there is no validity of that particular trade secrets until and unless the particular secret has been kept as a secret.
So how do we ensure that its secrecy is maintained and it is not coming out from any of the employees who are working within the organization and who are working for that particular product or the technology?
Right.
How do
So
we ensure that it is protected moving forward,
very
even
well
when
said.
the founders are not there?
It's a very well question. That's is a huge in a gray space where the trade secrets, keeping it as a trade secret, is a challenge to the organization. But here also comes a picture of an IP person. He identifies what should be there as in kept as in trade secrets. Everything does not requires to be kept as in trade secrets. So he understands the particular things and particular aspects what needs to be there in case like we are drafting a patent application. So he understands the incomplete invention and he thinks what needs to be disclosed in that particular specification of the patent and what needs not to be disclosed in that specification. So based on that, he drafts the patent specification. And now coming to the trade secret things, what the trade secrets needs to be as in kept as in trade secrets, it should not be disclosed within the organization itself. Like the one who has invented, he only should be aware of the things, and the other person or the management only needs to be understand that particular things, and it should not be into the public domain even in itself within the organization as well. So that's how the different things can be divided into the particular trade secrets as well, and that should be known to a particular person itself. That can how it should be noted down, and it can be kept as in things as in trade secrets. So I guess that's answer.
Yeah. So next, moving on to Dhawal. Given the global nature of the fluorochemicals market, how does your company prioritize its IP enforcement efforts across different jurisdictions?
Okay. Okay. So thank you for questions. Actually, as a fluorochemical or as a corporate team or as a corporate company, so basically inventions comes from the business-driven areas. Like for every aspect of the company or every team, means like suppose business comes generally from the R&D perspectives. So the collaboration between the teams like R&D, legal teams or IPR team generates a business-driven IPR or key patentable inventions or key patentable values, which are helpful to make a global patents or which are also help in the branding and the promotions of the companies. So the business-driven key patentable values and meritable patents are generally the which one adds the key values in the different jurisdictions for supporting for protecting and the supporting the inventions, like every chemical or pharmaceutical businesses like ours are the fluorochemicals. So might Akshay sir give a better answer.
Hello. So I think your question was more related to the enforcement part of that.
Yes.
So I would say that the in-house counsels are the people in the organization. They can lead the enforcement part, and there must be a strategy in place. When you have IPR protected with you, you have your granted patents, the strategy should be that in-house counsel should have connects with the legal and law firms basically, and wherever possibilities of infringements are there, because IPR team also has to perform a parallel search for the competitors' landscape to understand that who all are working in the same technology, and time to time to see the products available from the competitor, evaluate them, doing some reverse engineering, and to understand that are they really using the technology what we have developed. And once some traces are available, the enforcement of the patent which is granted to be carried out with the external law firms with the all supporting evidence and data, and it should be enforced in almost all geographies wherever the patent is granted, because these are all geographical rights basically you can enforce. And the enforcement is only done by mostly sending the notices to the competitor, and sometimes the legal cases, once they are filed, there will be a lot of burden shifted to the defendant to prove that whether they are using your technology, in which way they are using, and what are the things. And once things comes out, it gives the impression that your enforcement is in a way that it is taken care seriously. And many organizations have seen that enforcement strategy is not, taken care in a way that it becomes a big tool basically to the company. Because once you stop the product of others who have copied your technology, you are actually fetching a lot of revenue from that, because you are then becoming the single person for that particular product basically. And enforcement of right is making a strategy for that and making a planning with the external law firms, and suitably enforcing is very, very important. It's a need of time. And organizations should understand that with in-house counsels, they can prioritize this kind of strategy for the granted patents, which are already being practiced, and commercialize the product as well. So I think the enforcement is mostly done by the corporate IP team within the organization, and to be connected with the external law firms basically.
So, sir, are there any particular markets where you find enforcement more challenging? And how can we mitigate those risks?
This is a very good point, and I will say the enforcements are very difficult in India, and I can say that the enforcement is very good in US and Europe. And the reason in India for the enforcement is that the penalties are quite less, and people can copy and they keep producing the product, and the cost affordability is one of the reasons where people come out in the court that, it's an affordable product, my cost is much lower, while they don't understand that when the IP was generated, there was a lot of investment done by the R&D, by that particular organization to come up with that process. So copying, once it is done and it is proved in the court, minor penalties are there, and people have come out from that. And there are other reasons basically, because employees in most of the organizations, especially in the R&D, when they switch over from one organization to the other organization, if the proper employment agreements are not there, especially employment non-disclosure agreements are not there with the scientists, there is a lot of possibility of leakages of the technologies and information that leads to significant loss, which I think often is not there in most of the bigger geographies where IP has a different value in itself. And the agreements are to be enforced right from the beginning when you join the organization. While in India, most of the bigger companies also, you don't have employees non-disclosure agreement to be signed, especially the scientist non-disclosure agreement, because they work, they earn salary, they do develop intellectual property, and they are more prone to leave the organization by virtue of various reasons, and attrition and other things basically. So important thing is, once the intellectual property has gone with the scientist to the other organization, and then copying happens very fast, and things goes in a way that the technology can be developed immediately with no investment on R&D, and things can be in more difficult way.
Thank you, sir. Moving on to Shweta. With tools like ChatGPT, now writing text and also generating images, who do you think should own the output?
So, thank you, Manushi, for the question. I have a threefold approach to it. Copyright, like AI-generated content, has the copyright protection, like a developer can have the protection, right? The one who creates the prompt at a user level can get the protection, or someone, a company like OpenAI, who develops the software, who owns the software, right, can get the protection. So it is a threefold approach in which I am aligned with the approach that author should get the protection, since like if we see, if we say like in a case of photographer, right, so if we say that camera manufacturer should get the protection, right? That doesn't make sense, right? There was a level of skill that was required by the photographer who clicked the photograph, right? So in the same way, prompt engineering is a skill that is to be learned, right? To generate quality prompts. So when codes can decide on the basis of the prompts that are generated, right? If the prompts are not generated on a quality level and there is no human intellect involved in it, right? That may not be copyrightable. But the ones where a lot of skill is involved and a lot of brainstorming is involved, the niche in which the user is generating the prompt is involved. So over there, definitely copyright protection should be there.
So ultimately, who will be the one who is giving the prompt will be the author?
Yes, yes. That is what
Okay.
I think so.
So what are your views on this, Akshay sir?
That's very correct that who generates, who creates the prompt, it should be the, yeah.
Yes, yes. Also, like in UK, we have separate classification for the for the people who are uh, creating the, I guess, like facilitating to create the prompt, right? They are getting the protection they are recognizing the protection in that way. And in US, human involvement is necessary, right? Also in EU, we see that there is a condition that human intellect should be involved, right? But in India, we don't have any such recognition yet.
So, Akshay, so what I would like to understand is, in a science-driven organization, embedding the IP protection right from the R&D stage, is it possible, or could there should be any internal policies, or what are the best practices that which will ensure that the innovations are not lost or they are leaked outside the organization?
It's a very good question, actually, and I think it needs a serious attention, basically, because what happens is when I say that, and to be very frank here, these are all my own comments. It should not be interpreted, the comments with respect to the organization. So I'm representing on my own, basically, and when I'm saying these are all based on my own experience. And when I say, the organizations, the businesses, especially in the chemical and pharma and agrochemicals as well, they are all mostly IP-driven businesses because the new products which are coming up, they are being copied, and companies are waiting to launch the products just only after the expiry of the product patent. So it's not only the agro and pharma products, it's also for the fluorochemicals also. Many patents are there where you have to keep on waiting, or you do the licensing of those technologies and then you launch your product only after expiry of those. So sometimes it becomes difficult for the business team that they have to really wait for that long to launch the product, or they have to go immediately by virtue of creating some changes in the product and it should become a novel product. So what happens is they drive, means business team usually drive, interact with the R&D, interact with the IPR and say that, you please start doing R&D work on a product which is having these specs and they should be better than which is already granted or existing product in the market. So we should have to develop our more competitive product compared to that. So you might have seen that a lot of product comes out with innovative features on the previously known products, basically, and that comes out from the R&D by incorporating those additional features which gives value to the product much more than the product which is existing by the innovator. So what happens is that when R&D start doing work based on the business requirement that you have to develop a product with enhanced features, with the qualities, with the other things. So they do a lot of IPR work. They do understand, they interact with the in-house IP team, and they get the entire landscape, what amount of work has been done. And they start developing the process or the product in the R&D at a next level to find out that how to incorporate those features which are better than the innovator. So then innovation comes in play, and there are a lot of R&D rigorous discussions are required to arrive on those features to be incorporated in the product. And while doing all that, when you get first time something in your hand as a new innovative featured product which is already there better than competitor, and you have already compared, you have done analysis, you are having some proof of concept of that you have something. So it's good time for the R&D to interact with the intellectual property team to say that I have something which is not known, these features are not known, this process technology is not known, so please do something for doing a protection before launching the product. So I always say that it's recommended to do a patent filing right from the beginning when you have arrived on the inference that you have got the proof of concept in your hand, and you have a process, you have a technology which is already there in your hand. Though it is in the preliminary stage, it's not developed and optimized fully. But in the very preliminary stage, it is recommended to be discussed with the IPR team, and if required, it should be filed a patent as early as possible. And wherever things are required, some design-related features which are also required, they should also be filed as a design patent, because sometimes in technology, engineers propose some designs for a project near. They say that, okay, if you do this kind of designing in the plant and you do this kind of process, you can save a lot of time, you can save a lot of cost also. You can, come out your product in 5 hours or something, while the earlier process known is giving in 18 hours. So you do a lot of time saving, cost saving, and then your automation comes also in play. So you have a lot of things as a matter of intellectual property in the very beginning of R&D development. So all is recommended from the IPR perspective is to keep filing the patents in the very beginning, whether they are provisional applications, but it's always important that you should have proof of concept in your hand. It should not happen that you have filed something based on the conceptualization in the mind, and it didn't work out, and you say that, okay, it was a provisional, let it get abandoned, I am doing some other work. But subsequently what happens is, when you got some minor proof of concept and then you have optimized the process, you got some more features added into that, keep protecting all those patents to be separately. It should look like that you have a bunch of technology patents in your particular domain, and when your product gets matured for the commercialization, means your pilot trials are over and your commercial product is also coming out as a first batch, then you have almost all the things in your hand for your technology. So best is to complete all those and start filing your international applications, taking advice from the business teams that what all geographies you are going to launch our product. And then they can definitely recommend that we have possible businesses in US, Europe, Japan, China, New Zealand, or whatever countries of interest they can recommend, and they should be filed in those countries as well, and to get the value of the IP. So it's all recommended that as early as you get the invention in your hand, you keep protecting, and you may get the values later on.
So, sir, recently I was also reading a case of Teva API India Limited versus Natco. So, this case emphasized the importance of internal IP documentation and disclosure practices. Can you just throw some light on this particular case?
Regarding this Teva and Natco case, I could recall this was a case of a drug which is glatramyr acetate, and its commercial name was Copoxin, and the drug was useful for multiple sclerosis, and it was an immunomodulatory disorder, and it was once a well-known drug, and the Teva and its research company Yeda Foundations, they have developed the product glatramyr acetate as a product very useful for remitting resistance, multiple sclerosis. And what happened later on that when the suit was filed in US for the ANDA filed a competitor to me actually. So there are many factors, and when you go in US, Europe, most of the licensing are happening for the IT related inventions, computer related inventions, software related inventions, which is happening, and you'll find lots of patents are being filed by IT companies. So their licensing is very common basically, and they are also being done in India as well. So I'm only saying that still R&D has to do a lot for creating licensing opportunities and to do meaningful in the time to come.
Moving on next to Shubham. How do you assess and value such IP assets, especially in a specialized domain like fluorochemicals?
Assessing the value of an IP generated by a chemical industry, firstly, many of the things has been covered by Dr. Akshay sir. Like there are the R&D of the organization needs to be evaluated. There are the things that IP audits can be done by the IP personnel along with the financing and the different domains. What they can conduct is they can conduct a detailed analysis searches of IP audits, like what are the things that there are in the organizations needs to be protected through the inventions or needs to be protected through the different IP tools such as patents, trademarks, copyright, designs. So all such detailed IP audits will help understanding and assessing the intellectual properties what are there within the organizations. And IP person will also plays a role that he will think of what needs to be protected through IP or what needs not to be protected, because everything's not needs to be protected as an IP. There are the multiple things that needs to be kept as in different things and kept as in different trade secrets and different tools as well. So that IP audits will help to assess the what are the in-house within the organization inventions and what are there within the business goals as well, because not everything needs to be done. There are the future innovations as well needs to be protected. So we discussed the mere incremental things and all those things will be assessing to the future inventions and future innovations as well. So within the organization and the future within the business goals, all needs to be assessed and accordingly needs to be protected through different IP tools.
Okay, so the protection is must.
Absolutely, and it is.
Okay, moving on next.
I would like to add a few points. I think what Shubham has mentioned, that protection is must, that is true, but I always say that the more the amount of work done by the R&D and the more the discussion happens with the R&D scientists and the more they are encouraged to do experimental trials, the more outcomes can come basically. So what is important is not the number of protection basically. The important is how much you are able to generate a meaningful inventions from the R&D scientists. So to do all that is to work with the scientists both from the IP and the business development perspective to encourage them to come out with the features which are non-infringing, not only non-infringing but very unique features to expect from them so that they can generate more those kind of things, and then you can have something meaningful as an invention for the organization.
Moving on next to Shweta. See, blockchain and NFT startups operate globally and sometimes anonymously also. So how can such companies protect their IP like code, digital art, brands under the current Indian law?
Protection of NFTs can be very well done under Copyright Act, right? But however, when we talk about the transfers, right, we are selling the NFTs, but we are not giving them rights for the transfer. So those transfer rights remain with the person who generated the NFT on the first hand, right? So in case the buyer of the NFT, he wants those transfer rights, a separate agreement for the same needs to be drafted. right? There needs to be awareness in society in the startup culture, especially with respect to separate agreements that need to be drafted, right? For IP licensing, like NDA is not sufficient, right? When it comes to code, right? The companies take the code from the developer and they pay them the amount and that's it. But you need to understand that you need to draft a contract, you need to sign an agreement also with the developer for getting the rights on the same. Unless and until that is to be done, uh, the developer can always question the company and create issues for the company. So I feel there is lack of awareness with respect to how to deal with technology and the legal aspect of it, right?
So how do we bridge this gap?
First of all, I feel the lawyers, like the people who are in IT, uh, they need to be encouraged to opt law so that they can learn law, they can study law, and they can help us in building. The policy makers also should be in such a way that they should have the knowledge and the expertise of both the fields, right? So only then we can bridge the law. Like globally, US, UK, EU, they are also bridging the gap, right? But India is lacking at it. So I guess uh, we have like a lot of Indians from like go to countries like US, like we know Sundar Pichai, right? So we have great minds uh, who are working globally and who are sitting at positions globally. So there is not there is no lack of intellect, if we say, but the right use of intellect is the correct, I guess.
So there was also this case of Yuga Labs versus RIPS, which was on NFTs. What was that case about?
So in that case, NFT, it was decided that NFT is also is an asset, right? Before that, NFTs were not declared an asset. So in that case, we in detail figured out, the court in detail mentioned how NFTs can be covered under.
So it was relating to trademark infringement and cyber sport.
Yeah, it was related to copyright infringement, to be
Yeah.
precise. Yes.
Okay.
In this, in my previous, one of my previous conference, I think in GIPC, there was a discussion on trade secrets basically, and as on date in India, there are not much in the trade secrets basically. There are no regulations much to be emphasized basically, but I think in that discussion there was some point which has come out that there must be some trade secret depositories to be developed, and they should be controlled by the intellectual property offices or maybe international offices like WIPO, where the trade depositories can have assets of those training related data and those kind of relevant data, because that's a different kind of intellectual property and it's actually assigned through an agreement. But as she has rightly mentioned that agreements are not adequate basically. When you say something, you have a data and you have deposited in the trade depository and you have given that data rights to the company where you have given. So it's actually the entire trade secret you have given to the other one basically. And there is again possibility to get leaked out from that to some other also, because this data is generated with lot of money spent in the beginning, and so that was a provision, and I think people are working on that trade depositories, once they will be generated, there will be number and codes assigned and you can submit the trade secret data in that certain depository, which will be internationally governed, and it all depends on how you utilize those things. But I think there is a lot of debate is going on, and things may come out in that provision. That's the way I have understood. I am giving my view based on that.
Yes, DPIIT also has come up with a committee where they are trying to deal with AI and Copyright Act, right? They are trying to revamp whole of the legal structure with respect to the new technology that is coming in the market. So I guess we will see new regulations soon in the market.
So moving on next to Dhawal, what I would like to ask you is how different is patent registration in different countries like India, US, UK or European Union or Japan? How fast can we get patent registration in the above countries? How is the process different, or what are the challenges which any company will face if they are trying to register a patent for their client in that particular country?
So it's totally depend on every country law.
Yes.
So every country has its different law for the protecting the inventions, whether it is patent or whether it is trademark or every invention. So if you want to protect your inventions globally, so there are two ways. Once you file a national phase, and second you file through a WIPO, that is PCT application. So I think PCT applications is one of the good route to file a patent in different jurisdictions at one international applications through a different national phase entries you have, and through it you go means you go in different jurisdictions from that only one particular inventions. Then every country has its own law which is re-examines every patents, and on that basis you have a different kind of process in which your patents goes through that particular examinations, and whether means if a patent that granted in India, it is not necessary that granted in US or that granted in Japan as well. So it's totally depending on the every country's its particular law.
So I think what your question was that how easy or difficult to get it granted in different countries.
Yes.
My answer is that it all depends on the quality of your invention. If your invention is a simple, mere incremental aspects of various process or something, there may be chances that it may not get granted in most of the geographies. And there is a possibility if the things are very good in the invention, the merits are there, and novelty is already known in the WIPO search report, and inventive step is also acknowledged, there are chances that it may get granted. In certain countries like in US, I have observed that things are getting granted easily when you really have some merits and you have acknowledged all the prior arts and your background clearly demonstrates that what is known in the state of art and what you have come out as the novelty features and inventive step of that. Yes, there are difficulties in India to get the patent granted because these sections like 2J1 and means inventive step, and section 3D and section 3E and section 3I. So these sections are so stringent in India that they don't allow the patents to be granted easily in India. And when you talk about the Indian Patent Act, entire section 3 talks about what inventions are not patentable. So when you see that section from A to 3A to XYZ, you will realize that there are lots of things which are not patentable in India, including a biological product or biological microbe or something which are already naturally existing. So while if you see the case in US, you will find that these provisions are not there. You can get everything under the sky is patentable where human intervention is there. So you developed a microorganism with the genetic change in that, and it is useful for fermentation to be carried out in 5 hours or 10 hours. So you may get patent granted in India. You may get patent granted in other countries, but may not get granted because it's a naturally organism and you have modified that. So I'm saying that getting patent grant in India is sometimes difficult, as we have observed, because objections from the Indian Patent Acts are mostly under these provisions, plus Uh, it takes time also in Indian Patent Office to get the search report to come out and examination report, and mostly these objections are becoming barrier for even innovator companies as well, because they have got their patent granted in US, but they are not allowed in India. So if you see section 3E, it talks about mere admixture of two, three components, and you get some product which is A plus B is equal to AB. So Indian Patent Act says that you cannot get a patent for A plus B is equal to AB. You should get something A plus B is equal to X, Y, Z or something. So there should be some synergistic, unusual or peculiar effect which is to be observed in the product. So that is the thing which is, being questioned. And it's true in the Indian perspective, because these sections are created as a lot of barrier to the inventions for most of the innovators outside, because when you come out for a product with different features, with different properties, they are getting granted in US, Europe and other countries, but they are not allowed in India. And India says that incremental inventions or evergreening of the patent is not permitted here. And that's because the cost of the product and availability of the product in India, it's get delayed because of patents which are subsequently getting granted. So it creates a kind of hurdle for the product availability to the users. And mostly in case of pharma and drug, this situation is very prominent, that products are getting delayed because of evergreening of the patents. So Indian Patent Act says no worries about that. It's only one product, one chemical entity which is granted. After that, if you come out with any other new use indication of that or a new formulation or whatever is there, you will not get the patent granted for that. So it becomes sometimes a hurdle for Indian companies as well, because when they face the challenges in European or US countries, they see that the patents are granted and they are well acknowledged for the innovations, because when a drug which is known for the cardiovascular disorder, it works for some other kidney or other indication, and it has come out with lot of hard work from the scientists as a new use of that, it really makes sense for those kind of products with the different use to be allowed for them. But that's not permitted in India. So my perspective of saying was that getting patent granted in India is quite difficult basically, and compared to the other countries basically.
Just to
If I understood your question, it looks like that quality of invention is truly acknowledged in US, and they also believe in the quantum of work which is done to get the new features which are invented. Now suppose a drug which is known for multiple sclerosis is also invented in a lesser quantity of dose. Suppose a 40 milligram tablet was given for a particular use, and 5 milligram of that drug can be used for some other, either fever or maybe brain disorder or some other kind of indication. So it's not that a new feature is discovered just by a thought process. They have invested money to understand that why this feature and this property which is existing in the drug, in the chemical entity, was not identified. So they have done clinical trials, they have done a lot of data generation, and they have done proof of concept studies, and they realized that for this particular indication only 5 milligram tablet is sufficient instead of 40 milligram which you are using for multiple sclerosis. So this quantum of work and the amount of money which is spent on that was the reason to get the new indication patent to be granted to that. So I am only saying that when you justified your invention based on the merits and the quantum of work and the amount of energy you spend over that in R&D, it is acknowledged that these patents can be granted. But India says that in section 3D, mere discovery of either new salt or indications, or section 3I says that no new indications can be granted for the same chemical entity because chemical entity is same. So these are the reasons which makes the, actually it's our act which says that, you have to follow this. And examiners clearly come out with the objection based on the particular act, what are not patentable. So they come out with simply by section 3I that it does not allow a new method of use for the same chemical entity. So I think I have answered your question.
Thank you, sir.
So I thank you to all our esteemed panelists for sharing such thoughtful perspectives, and to our audience for your active participation and bearing with us through all this time. Thank you.